Hello, this is Judge Matthew Sabaugh from the 37th District Court, and welcome to Judge's Corner. I've helped to develop this program to give viewers the opportunity to learn what takes place inside a courtroom and also to learn about the legal system. Each episode will feature a specific area of law and also will include interviews from members of the legal community. Today's episode will provide an introduction of the 37th District Court. Welcome to the 37th District Court. My name is Judge Matthew Sabaugh, and welcome to Judge's Corner. This is a new program that I help to develop to give citizens the opportunity to see the inside of a courtroom and to learn about different legal facts and legal procedure that occurs in a courtroom. And I'm going to do this by discussing some of these things, and then also in other shows I'm going to be interviewing different participants in the legal process, including judges and other members of the legal community. Many of us have seen courtroom dramas depicted on television, but many citizens have not been inside of a courtroom. And the District Court is here to serve all the citizens of Warren and Centerline in the state of Michigan. And I think this show will give citizens who ordinarily wouldn't go into our court the opportunity to find out what's happening and what occurs in the District Court. The 37th District Court is a court of limited jurisdiction. We're part of the state judicial system. We operate under the direction of the Michigan Supreme Court. The fines and fees that are collected at the 37th District Court go to the state of Michigan, the county of Macomb, and also the cities of Warren and Centerline. And those are collected and distributed according to a statutory formula. And the 37th District Court comprises of 4 judges, including myself. There's also the Chief Judge, Judge John Shimura, the Chief Judge Pro Tem, Judge Jennifer Faunce, and then also the other District Court Judge is Judge Dean Acilio. And all the judges in the city of Warren and Centerline, the 37th District Court, must be elected, and we must be attorneys, and we're elected for 6-year terms. One of the first things that I hear from people that come into the court here is how busy we are. We are the 3rd busiest district court in the state of Michigan. We only are behind, I believe, Detroit and Grand Rapids. There are 50 employees in the 37th District Court, as well as the 4 judges. The court handles a wide variety of cases. There is a lot that goes on behind the scenes, outside of the courtroom. And so we have a great support staff that makes sure everything, all the files are handled properly and that the public is served well. Everything in the district court is on the record. On the record means that we have a court recorder in the courtroom that records all of the cases. She then saves those recordings. We're now on a digital system, which we just upgraded to. Those are saved in a secure digital location. And if someone had requested a transcript of any hearing in the district court, they could request that from our court recorder, and she would then transcribe that transcript into a written form. Now, oftentimes these transcripts are used when someone appeals a case. And people have the right to appeal a case in the district court. Those are appealed up to the circuit court. So in case someone appealed a case in the district court, usually they would order the transcript of the district court hearing so that the appellate judge could review the record that occurred in the district court. Last year, the 37th District Court handled over 65,000 cases. Now, breaking that down, we handled 2,000 criminal felony cases. We handled over 2,000 criminal misdemeanor cases. In addition, we handled over 45,000 traffic misdemeanors and civil infractions. A civil infraction is an ordinance violation, typically under the State Motor Vehicle Code or the city ordinance. It's not a misdemeanor, so you can't go to jail for a civil infraction, but you still have the right to have a contested hearing Because a civil infraction could result in points in your driving record through the Secretary of State, and it also, as we all know, could result in increasing your insurance premiums for your auto insurance. So civil infractions, probably by numbers, the majority of the cases we hear are tickets, civil infractions. The city also has ordinances that are civil infractions, including the blight ordinance. Those are civil infraction violations. And other types of property maintenance infractions are civil infractions. So a person, when they are cited for a civil infraction, they have the right to have a hearing. Now, they don't have the right to have a jury, but they have the right to have both an informal hearing before a judge where they would appear without an attorney, and they also have the right to a formal hearing if they wanted to go out and hire an attorney. Now, the court does not appoint an attorney for a civil infraction. Appointed attorneys are available if you're charged with a criminal offense, a misdemeanor or a felony. And that's because you could go to jail. On a civil infraction, again, you cannot go to jail, but you still have that right to a hearing. And so we do hear a number of traffic cases where the litigants come forward and the police officers come forward, and the court has to make a finding of whether or not they're responsible based only on the evidence. On the civil side, we handled over 7,000 civil cases as well as small claims cases. A civil case is the type of case that often, when people think of what a lawsuit is, that is a civil case. That is a case where someone has been wronged. It's not a crime, but someone has been wronged and they want to redress that in the court system. They can sue the other party for damages. And in a civil case, the court could not sentence someone to jail, but the court could award damages, or a jury could award damages to the plaintiff against the defendant. And that would be a typical civil case. In district court, we hear civil cases up to the jurisdictional limit of $25,000. So the only suits that could be filed in district court have to be below that threshold. Anything over that has to be filed in the circuit court in Mount Clemens. A small claims case, the small claims division is a smaller division of the civil division, and small claims cases are still civil cases, but they're civil cases where the damages are less than $5,000. And in small claims, it really was created to give citizens the opportunity to, again, allow them a venue to address their grievances against someone else in a civil case without hiring an attorney. You cannot have an attorney in small claims. You cannot have a jury trial in small claims. It's decided by the court. And also you cannot appeal a case in small claims. But small claims is really a great way for people to bring these matters to court and not have to go through all the expenses, especially when your damages are less than $5,000. We also handle landlord-tenant cases where the tenant does not pay rent. The landlord could seek to evict the tenant from the property, as well as some land contract cases and other eviction proceedings. And we also do marriages in the 37th District Court. And so that's really a fun part of the job, to do the wedding ceremonies.
I now pronounce you husband and wife. Congratulations.
There are a million places you'd never consider texting. So why would you do it while driving? Leave risky driving to the professionals. Stop the texts, and together we can stop the wrecks.
Can you consent with me? Imagine what you'd see if every child had a book to read.
So the mission is for us to get a book to each and every child.
So let's join hands, book people unite, unearth hidden passion. Come on, we'll have a good time.
One book can be the first element, helps to change a life. Book people unite.
Read to a child today and spark a lifetime of ambition.
The 37th District Court also hears criminal cases. There are two types of criminal cases, misdemeanor cases and felony cases. Misdemeanor cases in the district court are heard at arraignment, pretrial. The bond is set at arraignment, and then also the court would hear the trial, whether it's a bench trial or a jury trial. The jury trial would occur here in the district court with the jury of 6 citizens would appear in court and decide the case. And also the court would sentence on a misdemeanor case here. The other types of cases that we hear are felony cases. A felony is a case that usually has a penalty over 1 year or more, punishable by imprisonment in the state prison system. Felonies are heard in the district court at arraignment and preliminary examination, and the court also sets the bond on felony cases at the arraignment. Now, the primary hearing that's heard on felony cases in district court is a preliminary examination. A preliminary examination is an evidentiary hearing. It's called a probable cause hearing, so it's not a trial where the prosecutor has to show proof beyond a reasonable doubt that the defendant is guilty. But instead, the prosecutor here has to show that there's enough evidence to show that a crime was committed and that the defendant committed it. And if they can show that in the district court would bind the matter over to the circuit court for a trial. So that's what's often called a preliminary examination. Those are conducted in the district court for felonies. If the court determines that there is not enough evidence at preliminary examination, the district court could dismiss the case or could amend the charges, reducing them. When a criminal defendant is sentenced, the judges have the discretion to sentence them to incarceration, to jail. We also have the discretion to sentence them to probation. And probation is probably the most often used alternative to incarceration. And before a defendant is sentenced to probation, typically they are sent down to the probation department. Here in the 37th District Court, we have 2 probation officers. They would conduct what's called a pre-sentence investigative report. They would do a thorough background of the defendant, including criminal history, any substance abuse or addiction history, as well as any mental health issues, and they would in turn make a recommendation to the sentencing judge by returning that pre-sentence investigative report to the court. And of course, the defendant and their attorney would have the opportunity to review that before sentence, and all that information is shredded once the court is done with that. But these probation reports, these pre-sentence reports, really assist the court in fashioning an individual sentence for that defendant. The goal of probation is to rehabilitate. As judges, we have 2 goals at sentencing: to punish and to rehabilitate. Probation gives us a tool where we can have a defendant get the help that they need. They might need counseling. They might need drug or alcohol rehabilitation. It might be inpatient therapy. It depends on the severity of their addiction. But probation really is an effective tool. And we have a very busy probation department. We have over 700 probationers and only 2 full-time probation officers. So we're doing a lot with really few resources, and we're finding that when people get the help that they need, that they don't reoffend. And that's the goal of probation. Now, if someone violates probation, the judge can always revoke probation and incarcerate the defendant, essentially terminating probation. And the way that would occur is the probation officer would notify the court that there's a violation of the judge's orders. The defendant would have the right to have a probation hearing, and of course they would have the right to have an attorney there as well. And at that point they could have a full hearing, and if the court finds them guilty, they would be sentenced.